Yes, can I go on?
Yes, please go on.
Good. I think, Samson, good morning to you and good morning to your Charles viewers. Good morning to Senior Sassari. But you see, listening to the submissions he makes on the ruling, clearly, I'm clear in my mind that he hasn't read the ruling. It's very clear.
Which part?
All the ruling, the entire ruling delivered by the court on the 6th of June 2024. It is clear. If you try to copiously quote portions of the ruling for him to look to change his position, he stuck to the same position and didn't change the position. Clearly, he hasn't read the ruling. It's very clear. Something, what has brought us here? Now, let me take my time and in sober reflection, deal with this particular matter. We are here because somewhere in 2014, 2016, a charge was said to have been filed against Mr. Atufosin and two others. Now, one is been discharged, so he's no longer. That they've caused financial loss to the state.
That's 2021, December. 2020 and the trial 2021, right?
No, 2024, 2026. That is when the facts.
No.
When was the charge filed?
The case was filed
2021
in December of 2020, okay. And then in January of 2021, it began.
It began?
Yes.
Good. Very good. Now, Samson, this case that was filed in 2021, at the time it was filed, I'm very clear in my mind that the Republic had their own evidence, done their own investigations, built the theory of their case, put their facts together, and then filed before the court. There was no issue about what? Recorded a tape at that time.
That's correct.
Good. The prosecution mounted a box, called their witnesses, closed their case. A1.
Okay, so it is this way. Filed December 2021, and in January 2022, the process began. Yes.
Right. But then it is clear that the issues complained of started between 2014 and 2016. These are the facts, isn't it?
That's right.
Good. Now, Samson, at the time when the prosecution entered the dock, mounted the dock, led evidence in the case and everything, closed their case, the issue of so-called doctored tape had not arisen. For even backtrack, at the time when settlement conference was going on, document was being exchanged by the parties. The so-called tape had not arisen. The case closed. Submission of no case was filed by A1 and A3.
Richard Japa and
Atufosin. And this is very, very, very instrumental. The court said, no, it's a case for you to answer. Now, let me go to that point. You see, it is very, very, very instructive. Very, very instructive.
I've read the entire ruling on the submission of no case.
No, yes. It's very instructive in terms of the findings made by the court that a case has been made for them to open their defense.
Right.
So let me refer you to page.
They are only supposed to punch a small doubt
exactly
in the Republic's case, and the Republic will lose.
Exactly. Now let me go here. The judge said, and I'm referring to page 4 of the ruling that we are dealing with. He said, submission of no case dated 30th March 2023. This court concluded that a prima facie case has already been made to merit all the 3 accusations then to open their defense. Now listen, Samson. That the matter was settled. That the ambulances in the state in which they were delivered could not serve any useful purpose. But the assertion was made by the cross-examination and the evidence put forward, particularly A3, that there were moves to fix the defects, thereby proving the case that there was no loss occasion to the state. It means that at this stage, there is a case which has been made that the loss has occasion. But as to whether the loss is willful, and who caused the willful act, that is yet to be determined.
And I'm happy you read this portion.
Good.
You know why? Because I had heard commentaries, including respectfully from Sami Jamfi, right after this decision throwing out the applications. That suggested that the judge had done something in predetermining the matter.
No.
By suggesting that the state had established that the vehicles that were delivered were without useful purpose. But if you read the decision, she actually highlights this. She says the matter was settled that the ambulances, then she begins to highlight, in the state that they were delivered, that's highlight, in the state that they were delivered, could not serve any useful purpose. She did not say, emphatic, that the matter has been settled, that the ambulances could not serve any useful purpose in the state that they were delivered.
Good.
Yes, go on.
Now you see something. At this stage, then A1 now mounts the box. Leaves evidence in chief, is cross-examined, call witnesses, 3 of them, and closes his case.
Atoforcing.
Now, Atoforcing is here. He said, further, there was the issue of what authority the first accused person exercised what he asked for the LC to be issued. It is a case of the prosecution that the LCs were issued without due cause and authorization. The prosecution is stating that A1 had no authority, had no authority. He stated, among others, that the agreement that culminated in the delivery of the defective ambulances, which cannot be used in the condition that it is. Now, A1 also called the Minister for Finance, who came to testify for him, and closed his case. All these stages, there's nothing called recorded tape. You see something, and this is very instructive. Prosecutors go to court, do their investigation, build a theory of their case, take the evidence with them, put it before the judge. Just accept that there's a case for you to answer. You also come and mount your defense. A1 closes and it's off the dock. A3 now comes because A2 has been discharged. Then at this stage, you start your evidence in chief. You put your witness statement in there. And then you are now being cross-examined by counsel for A1. A1 and A3 are on the same path. And even the direction by the judge that A1, lawyer for A1 cross-examine A3, is a settled matter of appeal, which they filed a stay.
Because they believe the Attorney General should do their work before they come in.
But they are on the same path. A1 and A3 are on the same path. Their interests are coterminous. All right?
So actually, for those of you who have not followed, one of the applications seeking to hold the hand of the judge not to do anything is in respect of this particular one that is pending in the court, because they are saying that you have done something that we disagree with you. You said, you said Atoforcing's lawyers should cross-examine Richard Japa before the Attorney General. We don't agree with that. That's not what the practice is. So that's why one of the applications was asking for a setting stay, and the judge refused it. Yes, go on.
And even in that period they filed, they didn't particularize any particular error of law made by the judge.
We will not go there. Let's stay here.
No, you see, I'm just trying to get the public, something, you and I, and my good brother, come on, say to her, you are not feeling well.
Let's stay here. Let's not attack the process on appeal.
Fine. We owe a duty, a solemn duty, to educate the public and to avoid this propaganda and the mischief and the public deception and all. You have to let the public know what are the facts of the matter, because until the press conference of the NDC that they did, I was not following this case. They brought us into this case. By now going to court to even follow the case. I have not been to court on this case before. Then we are now being told that under cross-examination by my very, very good friend Nimako on Japa, he now suggests that, well, there's a certain tape that you are trying to contrive evidence to lie and all the blah, 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 blah.
Because
this ruling,
whilst Japa is giving his testimony,
yes,
the Attorney General makes a certain intervention about suggesting that Japa is, doing the bidding of Atoforcing.
Yes.
Or is seeking to help Atoforcing.
Yes.
So Japa gets angry and then says, you have done this to me, I will spill the beans.
Yes.
And this is where we are.
So there is a beans. There is a beans, something. Having listened to this tape with sober ears, you will see clearly that all the statements that were being said by Jakpa did not emanate from the Attorney General saying, say this, say that, say this. It is very clear.
Why was he not protesting them?
Who was protesting?
The Attorney General. When you and I are having a conversation,
yes,
and I'm saying, you know, we have met here, you have been doing this. I'm saying I can't do this. Why was he not protesting?
You see, you will see from the tape clearly there was a disagreement about LC.
That's correct.
The age's understanding of what the LC and its import meant was different from what the Jakpa was saying. And then we were disagreeing. All of a sudden, because Jakpa knew that he was recording. He knew he was recording what he was.
He started sense, but you know.
He started now suggesting things, saying things, and even dropping names. Mm-hmm. He started dropping names.
My question is, why did the AG not object to that kind of thing?
Let me tell you something.
You have said this, you have done this, you have been seeking to get me to do this.
My conference with the AG, subsequent to the leakage of this particular tape, he tells me that, look, Gary, there is not a full tape. Mm-hmm. Because the discussion even started with the issue of me going for international arbitration and me seeking to get an adjournment because I was prepared for international arbitration. And the gentleman also having earlier on not been able to attend court, but then the bench was issued against him. And then being afraid that now if he doesn't go to court, then he may get another bench warrant. So I said, if that is so, then you have to now seek for medical report. And all that portion of the discussion have been taken away.
He said,
now, what report?
He said,
hold on. Hold on. What communication? Something I've known you for over 20 years. We talk. We talk on the phone. Yeah. We meet, we speak. What communication will you call me? You will not even greet me. No salutation, nothing. And all you see is that in the middle of the stream, I'm talking, or you are talking. Which communication doesn't start like that? I think that we have to approach this particular matter, and we are now, it's as if, because of an existence of a certain tape, one-sided tape which has come up, the issue before the court should be thrown away. That, because now somebody is saying that the tape exists, there is no issue about financial loss to the state, whether willful or not willful, whether the state has lost money or not lost money. Everything should be thrown away. And then we should now rely on existence of a certain tape recorded by one person to throw away the entire case, say there's a mistrial.
You know, if our jurisprudence accommodates mistrial, it doesn't mean that there will not be a trial of the case itself. Mistrial will mean that there will be a pause, and then you have to go and reassemble your facts and come back. But because of a certain development, including misconduct, it has led to, the case having to be stopped.
You will need to assess the entire case and see whether there has been a miscarriage of justice, whether there has been some contrivance or some evidence. You have to make a full assessment of the entire thing to say that, look, some injustice has occasioned the person, and therefore it's a mistrial.
Okay.
In this particular case, Samson, let's be honest with ourselves. From the very beginning of the proceedings all the way to the time Satofosi closed his case, who has introduced an issue that he hasn't been given fair hearing in the matter? Even when Jakpa himself started mounting the box, he had the tape with him. It did. The tape was there. This tape that he relies on now at this stage to try to cause confusion into all of us and to take our minds off, this tape was there. This tape, according to them, was recorded some few days or so when he had mounted the box.
The day he was going to mount the box.
So if he found the tape relevant, the tape was relevant to disproving this case or show some confusion in the Attorney General's case or whatever it is, why did he not at that time file for leave to amend the witness statement that, look, I think that this particular information is relevant to me, showing that my innocence. This particular tape, Samson, it's a red herring. The tape has nothing to do with whether the financial loss was caused or was not caused. And I'm surprised that this tape is now taking all of us our focus from the real issues in contention, which is whether or not somebody's act or omission has occasioned the Republic or willfully.
We all don't share the same view. You heard Ansari.
Oh, yes. That is why. I heard him. That is why I'm saying.
Resign or be sacked. Misconduct.
See, that is why I'm saying that. Something, listen. You see, we are confusing the matters. The issue about whether the Attorney General will resign or will be sacked, one lies with the appointing authority.
Their political decisions.
It's a political decision. Or he himself sitting down to say, well, maybe I want to resign. Okay? The issue of whether there is even a breach of our ethics rules is not the courtroom. It's not the courtroom. That is why the judge says, I'm not to deal with this particular matter here in the courtroom. Right. There is no rule of law or practice that is dealt with in the courtroom.
Right. There's an issue that is being raised about the judge not allowing the lawyers to move their motion and to argue.
Samson, I was in court. You know, I told you that I had not been following this case, but
I was there. I was just next door. I was in the other court. I was also busy.
Courtesy the NDC press conference. It made me now go to court to be listening to this particular matter. You know, just to leave everything I'm doing to just go and sit down and listen.
Right.
I was in court. Sammy was in court. He was sitting about 2 blocks from me. You know, the motion was moved. You see, I took back the delivery a decision at the Supreme Court. And
experts say 16
alloys.
Republic versus Court of Appeal, right?
Yes, 16 alloys.
What did they say?
Once a motion has been filed and all the parties have filed and responded to the application, and the date for hearing is due, the return date is due, a judge is not obliged to admit viva voce arguments in court. You know, the judge can rely on submission filed before the judge and determine the propriety of the application. Now, this particular one, my lord, the judge said, Mr. Tadosori had raised a legal objection. And then we hear a legal objection because it was on a point of law. And he spoke. I was sitting there. Someone was sitting there. He spoke. Attorney General responded to the legal objection. So when they say they did the legal objection, they didn't allow them to speak. I don't understand. What I remember they saying is that they are first on person at the Supreme Court. Yeah,
but the legal objection is separate from moving the motion.
That's what I'm saying. But no, why the motion has not been moved?
Your point is that there's law that says that's immaterial.
The judge said, I'm not going to admit oral viva voce arguments in court.
Good.
But the law is settled that once the due date, the return date is due, and even if you are not in court, the lawyers are not in court, the judge is not obliged to invite you to come and the judge can look at the paperwork and determine the ruling.
Do you realize that sometimes we misapply that authority?
Why?
Because the ratio is not actually that. Why do we give a date for hearing? When you file an application, why don't we say, because you have filed it, come for ruling? Why do we give a date for hearing?
Oh, something. We all know that by practice and procedure, you file an application, the return is fixed for you, depending on number, because you must give the other side notice of the application.
Good.
I mean 3, 4, 5 clear days, depending on what you are going to do.
Right.
And the nature application that you have filed before the court, the other side responds to the application. It's on record. You go there. The judge sometimes can look. I've been in court severally. Some judges will say, Nimako, you will not speak here today because you are going to give a lengthy submission. So you will not talk. You will not talk.
Familiar with it.
Yes.
But I'm
so
saying
you will not talk. And then they said they are going to rule based on the papers. And I said that.
You and I have used ex parte Eastern Alloy to make this point on Newsfile once. That, yes, a judge has the right to go ahead and do this.
Good.
But maybe you want to go and read it again. And you find that the ratio is different. That in that case, the one who brought the application was actually not there. And then the one who had to argue the other side went ahead and did their business. And then later he goes to, the appeal, complaining that I was not heard.
And the Supreme Court said that the court has no obligation. It's not obligation. That's in the letter. Right. Obligation.
Is there a practice direction to the effect that when you have complicated applications, the court should adjourn for at least 2 weeks for written submissions?
Samson.
It's a practice direction we know that it's followed, right?
Samson.
This case, do you think they should have been heard?
Samson. You see, let's take it this way. You and I are not the ones to give the judgment or the ruling on a matter.
The ruling is now.
No.
So the judge is sufficient. That's why we can discuss the ruling.
Wait a minute. You see, what you have filed your process in court, and The judge says, I need the 1 hour to write my ruling,
right.
a reasoning ruling. The judge's duty is to write a reasoning ruling, decision.
Right.
Not that some of them, the way some of them will write anything, but just write a reasoning decision on why he's going A or why he's going B. And the judge says, I need 2 days to do it. And he indeed comes back with a very copious decision, solid one.
Okay.
What else again is there to discuss? And in this decision,
there's a 33-page decision.
It is very clear.
33-page decision for the application by Richard Japa, and there's a 14-page decision also for Kesela to force. Let me go to
and this decision, lastly, has really exposed the propaganda, the lies that the AG had sought to contrive evidence or had made their part to say certain things. Indeed, on the tape, it is very clear that if you listen to the tape with open eyes, with not the jaundiced ears, you realize that it's Japa who was saying what he was saying, knowing because he was recording the communication.
Okay, Sami.